Steve. Welcome back to Constitutional Chats. We're so happy to have you here with us today. And we'd like to ask if you'll give some opening comments on our topic, and then we'll go to questions.
Great. Kathy, thank you so much for that generous introduction. And it's really wonderful to be back. It's a privilege to join all of you in these constitutional chats. I really enjoy it. So the case we're going to talk about today is Ohio versus EPA. It's got a lot of other names because multiple cases smushed together, all raising a common set of issues. In the background of this case is the constitutional principle of federalism, which you've probably heard of. That's the fact that we've got different levels of government in our country. The federal government, created by the consent of all the states and the people of the United States, and then the individual state governments, which are sovereign within their areas. And there's always a question about where the line is properly drawn between the authority of the federal government and the local authority of the states to deal with problems that can be addressed at the local level. And this case has to do with a very complex federal statute, the Clean Air Act, which in its structure creates a system of cooperative federalism, or is based on a system of cooperative federalism. And basically the EPA, the Environmental Protection Agency, which is a federal agency, sets standards for certain air pollutants. What amount of an air pollutant is acceptable in the ambient air at ground level for health and safety purposes? They set that standard. But then it's up to the states under the system Congress created. It's primarily up to the states to see that they meet that standard within their areas within the state. Congress also has imposed an obligation on the states when they figure out how they're going to come into compliance with the standard. Congress requires them also to limit or put controls on the emission of pollution within their state that can be blown by the wind to other states and cause those other states to violate the standards EPA has set. And if that's the case, the upwind state is supposed to put restrictions on the sources of that air pollutant within the state so as to avoid significantly contributing to the pollution in a neighboring state. This is called the good neighbor provision. And Congress lets each state decide its own plan for how it's going to meet those requirements. It then submits that plan to the EPA, and the EPA reviews it for consistency with the federal standards, federal requirements, and it can approve it or disapprove it. In this case, what happened was in 2015, the EPA set a new standard for a particular pollutant, ozone, which contributes to smog, and it reduced the amount of ozone that was allowed for meeting the standard. That required all the states to do new plans, new state plans. They had 3 years to do that. Most of the states submitted their plans on time in 2018. The EPA is supposed to take 18 months to tell the states whether they approve the plan or not. EPA took a lot longer than that. They didn't get around to disapproving or approving the plans until 2022, after the Biden administration had come into office. And then suddenly what the EPA did, I think much to the surprise of most of these states, is it issued a big order en masse disapproving 21 state plans altogether, saying they didn't meet the requirements. And that rule went finally into force in 2023. Meanwhile, EPA clearly have been working on this behind the scenes. EPA came out with its own federal plan for all 23 of those states, telling them what they needed to do to reduce the pollution that would blow into their neighboring states. And EPA can do that under the Clean Air Act. If it disapproves a state plan, EPA can substitute its own federal plan for the state plan that it has disapproved. But this was something new. This was a complex 23-state plan that EPA rolled out in 2023. And it involved complex calculations that were interdependent among the states as to what actions each power plant and each cement kiln and natural gas pipeline and paper plant in all these states, what kinds of actions they would have to take to reduce the production of pollution that flows into other states. The costs of the plan would be enormous for all of the states involved and all of the different industries involved, billions and billions of dollars to come into compliance with the plan. A bunch of these states went to court and challenged EPA, the correctness of EPA's decision to disapprove their state plans. And in fact, 12 of the 21 states challenged EPA's action, and all 12 got orders from different courts of appeals across the country. 7 different federal courts of appeals across the country issued orders blocking EPA's decision to disapprove their plan. That meant that there were 23 states in EPA's grand federal plan. 12 of them had gotten orders from different courts blocking EPA's decision to disapprove their plans. So that then caused EPA to have to rethink what it was doing, and EPA decided to drop those 12 states out of the 23-state plan, but then it decided just to proceed forward as if everything was okay with the other 11 states, as if nothing needed to be rethought about how it all worked together as a whole. So those 11 states, those are really the states that are now at issue here. 3 of the states challenged EPA's decision to move forward with its federal plan, and they went to court, federal court in Washington, D.C., and they asked the court to block EPA's decision, put it on hold while they have a chance to challenge the reasoning behind it. And the Court of Appeals rejected that on a vote of 2-1. They decided not to put a hold on the EPA's rule. So all of these requirements would go into effect for these 11 states. It's led by Ohio, Indiana, West Virginia, and a number of other states. And all the industries within the states, they'd have to start putting new technology in place and incurring all these costs. So what has happened is Ohio, Indiana, and the industry they've now appealed up to the Supreme Court, and they're trying to get the Supreme Court to issue an order to block EPA's rule from going into effect while the lower courts address the legality of the rule. And this case was argued on February 21st, and that's the case that we're here to talk about today. So thank you.
Well, thank you. That is a great overview. You did a great job of boiling it down to its fairly complicated case. And I think you laid it out in a really clear way. I know we've got a lot of questions, so I'm going to go ahead and turn it over to Janine.
Mr. Bradbury, thank you so much. Wonderful, wonderful. Thank you for gracing us with your intellect and your insights and persuasive arguments, all the things that are your talents. Wow. Well, this is, we talk about federalism a lot. We've learned a lot about it here on this show, Constitutional Chats, and federalism being the key to really what the Constitution really protects is federalism, that the states have rights. So what I believe is happening here is that the states are saying, are pushing back against the federal government. Like, wait, this is unfair. Interesting. This is the EPA, correct? And the EPA is a kind of one of those agencies that's become somewhat of a great power that is unregulated. You want to talk about that for just a minute? Because I know we're really talking about the Supreme Court and the lower courts having time to do before make the decisions before these things are impressed upon. I'm also curious what
Yes.
who were the 23 states. I think that's really interesting. But what about the answer to that question?
Well, I think you're right, Janine, that the EPA is a power unto itself. It's operates under very broad statutes, most of them drafted way back in the 1970s, a lot of them having passed at a time when Congress wasn't contemplating a lot of the issues EPA takes on under these statutes. And under, as you know, doctrines of deference that courts have applied in the past, including, perhaps you've heard of it, Chevron deference, which is again up for grabs in the Supreme Court this year. They're reconsidering Chevron deference. But under those doctrines of deference, agencies like the EPA really have an extremely broad scope in terms of the discretion they can exercise in interpreting these broad statutes to address whole new areas of issues and come up with creative, complex new solutions that they impose on Americans and on the economy that a lot of people think really should be the job of Congress to do. And because these agencies are able to exercise this breathtaking power, often that means Congress doesn't have to. And so these are difficult issues to address. They make a lot of people unhappy on one side of the country or another. So it's much easier for Congress to kind of kick back and say, well, let the agency take care of it. And that's what we've seen. In this case, you see EPA really coming up with a very complex, creative plan that it has clearly decided as an agency, we think this is the best way to solve this whole national problem of air pollution blowing from one state to other states. And they've just imposed it on half the country, 23 states. And they really didn't give each of the individual states much of an opportunity to come back and work with them to try to come up with a local solution that the state could find acceptable. And so they kind of just sort of gave the back of their hand to these federalism concerns that you referenced and blew right past that. It happens a lot in
And I
Washington
think,
these days.
yes, I know it's one of the big issues. But what's checks and balances. Our rights and our Bill of Rights are so fundamental, but it's our checks and balances within the Constitution that is just what makes us unique, what other people want to emulate, which prevents tyranny, and protects those rights. But what seems to happen with these agencies, in not just the EPA, but many of these agencies, they're unchecked because, and like with these decisions, if this had been in the legislative branch, there would have been representatives from the states, representatives from the districts in the House, and the people could go to their representative and say,
Right.
hey, we don't want to do this, or let's find a better way to do this. We go into classrooms all across America, and we ask the students to write a petition. It's amazing to hear what answers the students have to fix their problems. We ask, like, what problem do you have in your neighborhood? And the way kids with third graders are talking about inflation, but they'll come back and they'll have the genius of the people, as Hamilton talked about. It's fascinating to listen to elementary, middle school, high school students, list what the problem is that they want to take to the representative, but B, give their own ideas. And if we don't have legislators and senators talking about representing their people for these decisions that these big agencies are making, we have lost a big, big part of our constitutional value. And it looks to me, if we're talking about a check and balance, if the EPA is doing something like this, well, it's too late to go to the representatives who forfeited everything to these agencies that they built. Their
Yes.
only check is the court,
Right.
and the Supreme Court is, and I don't know that was really what the Supreme Court was meant to do per se, but they have no other place for a check. And so what I think this proves more than anything is just the importance of checks and balances, and that somehow our Congress has got to get these agencies under control, because the people have lost their representatives in that regard.
Well, yes, you're absolutely right. And also what you see is the way the issues come up, as this one did, comes up on an emergency docket at the Supreme Court, an application for an emergency order to block the EPA. And so if you listen to the argument that's presented or read the briefs, you don't see a lot about first principles, the role of Congress, constitutional federalism principles. You don't even see a lot about what the statute means or what the requirements of the statute are or should be. Instead, it's process arguments, because this is in an emergency context. And so the court has certain standards for issuing an order like this. And that's what all the argument is about whether the standards are met and what arguments might be made once they do get to court. And it's all rather divorced from the real constitutional principles and relationship between federal government and state governments, and who should decide, who's in the best position to make these decisions, which are so impactful on people's lives. None of that really gets aired in the Supreme Court when it's in a procedural context like this case is.
And then what happens if the court decides not to take the case? What if the court said, we're too busy, we don't want to look at this?
Well, there are at least 3 justices on the court, if you listen to the oral argument, who clearly think the case shouldn't even be in the Supreme Court because they don't think the standard is satisfied for emergency relief. That's the 3 more liberal justices on the court, Justice Kagan, Justice Sotomayor, and Justice Jackson. They clearly think that the case shouldn't even be there. And a lot of these cases, the court, it's a little bit of a balance. The court gets criticized for taking these kinds of cases. You may have heard the term shadow docket on the court. That's this docket of emergency applications for intermediate relief. So the court's not really reaching the merits of a case. They're just deciding, should somebody get an order that blocks, for example, an agency from doing what it wants to do while the case proceeds in the lower court. That's the kind of procedural question that these shadow docket or emergency application cases raise. And if you look on the court's docket, these are the cases that have an A in the docket number. That means application. That's the so-called shadow docket. And it's an increase. It's a good number of the cases every term in the court. And they are some of the most high-profile controversial cases that the court gets. But they're not really squarely reaching the big legal issues or constitutional issues that are at play, underneath the case.
They're just trying to stem the bleeding, so to speak, right? And can't really get to the source of what the problem is. Mm-hmm. Well, this is when I believe people, people in general, start to feel very desperate when they feel like they have no resources, and no one to be their advocate. And then people just get very disgruntled, very unhappy. And that's when tyranny, anarchy can arise, or revolution, or those type of things, when people feel they have no resources. It's kind of like dealing with a big business. It's kind of like dealing with a credit card company. Can I please speak to somebody there? But when you think that you don't have a resource to help you, that's tough, especially if something is not just. That's a really tough predicament to be in. I'm going to pass it on to Tova here, but I mean, what do you see as the answer to kind of reeling this back a little bit? Because the court can't there are a lot of people, I'm sure, that have similar situations, and they don't get heard. And what happens to them?
Well, just quickly, I think unwinding some of these deference doctrines, if the Supreme Court throws the Chevron deference doctrine out, which it's going to decide whether to do that this term, that will have a big effect, because then the courts will be more in the driver's seat in terms of deciding what these complex statutes mean and require, and not deferring so much to the agencies. So you'll get more definitive rulings that'll be consistent over time from the courts. And that should stimulate Congress to get back into the job, at least more predictably, of actually taking on some of these big national issues and deciding them in the political arena, where all American citizens can actually have a voice and participate in the process.
Well, as a landowner, I can see, both sides of this. If you have a stream, if you have a lake, right, and then someone up the block blocks your water from flowing down, then you don't have a lake anymore, right? It's just like the air blowing and things of that nature. But on the flip side, that had an eminent domain situation where they came in and they said they wanted to put, these huge electrical lines through my ranch. They had A, B,
Right.
C, and D, and E and F, and so I've had to deal with eminent domain, and then if you have the big government coming in and saying, "Oh, this is all wild grasses, and you're not allowed to build anything here," it can be it can be very devastating. And I think that that's the where it comes to the justice and having some sort of balance to these type of situations. Anytime anything gets really out of control and unjust, it's difficult. Now, you can
Yeah,
see both sides,
oh,
but
absolutely. And here we have the interests of the upwind states and the downwind states. And I should say they're not mutually exclusive. A lot of the states are both upwind and downwind, but there are interests in both at stake. The problem is when you have a bureaucracy in Washington that may not be accountable to the people, creating a complex plan and then imposing it on the states, what you may end up with is a situation where nobody's happy and they don't feel like they have any
Mhm.
recourse.
Yeah, people want to feel heard, and they want to feel seen, and they want to feel represented. And if they don't feel represented, then in my opinion, it's a danger for America. So, okay, thank you. I'm going to pass on. Thank you so much.
Thank you,
Here you go,
Janine.
Tova. Thank you.
Thanks, Janine. So I guess I wanted to go back to talking about the decision of the Supreme Court to take on this case,
Yeah.
and why I think they decided to take this one on, because as you mentioned, there is a bit of controversy as to whether the Supreme Court should have taken this case. As I was researching before the call, as you mentioned, some more of the liberal justices like Justice Jackson described the court taking on the decision of this matter when the states
Right.
hadn't yet lost the appeal, as she described it, as fairly extraordinary. And I read the opinions of some law professors that traditionally the Supreme Court goes last after a case makes its way through the lower courts, but
Yeah.
The argument that this case hadn't gone very far before the Supreme Court took it. So kind of why the Supreme Court decided to take this case at its stage, and maybe what the wider implications of this case are beyond just the narrow decision.
Yeah. Yeah. Appreciate it, Tova. Well, I think the standards the court applies when it decides whether to take the case and actually hear argument and decide it at this stage are very similar to the standards the court applies in deciding whether to grant the application and block the agency from acting. So they look at the initial application that's filed. Does it show that the party seeking the relief has a likelihood of success on the merits? So the first thing they have to show is they have to convince the court, or really this was 5 members of the court who would decide to take this because they structured it the way they did. It's 4 votes are enough, but really in a case like this, I believe it was probably 5 members of the court. You need to convince them that at the end of the day, you likely will prevail. You have good arguments against what the EPA has done. And so there's good reason to believe at the end of the day, you will prevail. And therefore, the question is, should you have to incur the costs that are being imposed on you by the rule right now? Because it's going to be 2 years from now, probably, until the case runs its course and there's a final decision on whether you win or not. And the second question then is, in that interim period between now and when you ultimately win the case, are you going to incur what's called irreparable harm, costs that you will not be able to recoup? And again, in order to get the case heard at the court, you need to show the court that you do have strong evidence of irreparable harm. And they put in all kinds of declarations from different people in industry and different people at states and the electrical cooperatives, et cetera, about the costs that the rule is going to require them to start incurring right now because they need to be in a position to meet the standards by 2026. So they have to buy all this equipment, put it in place. They have to change the way they're doing business. They have to do a lot to the tune of hundreds of millions and billions of dollars overall. And then they have to show what that will mean in terms of their businesses, their states, their state economies. And they have that all detailed in declarations. So I believe that for the court to take the case, they have to be impressed at the beginning that, yeah, you got a strong chance of winning. And yeah, it looks like you're going to be harmed irreparably to a very considerable extent if we don't give you the relief you're seeking. So it's very similar to the ultimate standards they apply when they decide an application like this.
Got it. Thank you. That's a helpful framework as we're going through these various Supreme Court cases and seeing
Yeah.
why some are taken on and not others. And then I wanted to ask a bit more of a broader philosophical question. I know we've been discussing this case as kind of an example of federalism and the balance of powers between the state and the bureaucracy, federal bureaucracy. And I know that there's a big argument that, is there a limitation to a federalist approach when it comes to something specifically like pollution or climate change, where by definition, the effects of a state's actions inherently will affect not only all the other states, but every country in the world. In the instance of climate change or with pollution, one
Yeah.
state polluting affects another state.
Right.
The argument of the tragedy of the commons, where
Mhm.
if there are no federal or international rules, it's in each state's incentive to kind of pollute as much as they want, since they know that they will only receive a fraction of the adverse effects. So I'm just curious, related to this case, what is your view on why federalism should still apply when this could be seen as a clear-cut example of an issue that is not, the effects of it are not limited within a state?
Well, you're right. The effects are not limited, but the effects also are local. And the costs of taking the action to comply with the requirements have very significant local impacts. Local impacts in terms of the jobs and economy and welfare of the citizens in the state, as well as the health and vitality of things like rural electrical cooperatives. There are thousands of them across the country, and they are very significantly impacted by these rules. Also, local businesses that have to comply with it. So there's lots of local impact, and a lot of the environmental effects are also within the state, because we are talking about local air quality issues. But absolutely, you're correct that some of that air pollution gets blown by the wind to other states, sometimes multiple other states. And Congress has authority under the Constitution to regulate interstate commerce. And under that rubric of regulating interstate commerce, they undertake these environmental laws. And so interstate effects of air pollution is a classic example of something where there's a logical and powerful rationale for Congress and for the federal government to be involved. But you see in the structure of the statute that from the very get-go in 1970, when it first enacted the Clean Air Act, Congress strongly recognized the balance of interests. And they wanted the regulation to be imposed and enforced to the extent possible, primarily at the local level by states. And they didn't say if the pollution crosses state lines, then it's going to be the federal government that regulates it. Instead, they put the obligation on each individual state to try to minimize the extent to which it significantly causes pollution violations in other states, and gave each state the opportunity to do that first, and then to work with EPA to try to figure out a way to make it workable. And then only if EPA finds that it fails to meet the requirements of the statute, could EPA substitute a federal plan for the state plan? But it wasn't intended to be the final word on it. It was always intended to be cooperative, a back and forth. So it's a complex scheme, but I think it reflects the difficulty of exactly the question you asked. Where's the line when the effects of pollution are clearly do cross state lines? And who should be the one with the authority to resolve those issues? Congress could have done it, entirely federal, but chose this cooperative federalism model. And it's complicated and it's difficult in certain situations. And here we are in a classic example of where it gets really difficult.
Well, thank you. And I only have like less than a minute left, but I was curious, after this very tortuous route that this, case has taken, what do you expect the Supreme Court to rule? Is there like an expectation because of the makeup of the court, or is it very much up in the air?
I think it's very much up in the air. If you listen to the arguments, as I say, 3 justices clearly are going to rule against the state challengers and the business challengers. Don't think there's any doubt about that. But other justices expressed some ambivalence. Justice Kavanaugh came right out and said during the oral argument he's undecided about it. And other justices were asking questions on both sides of the issue. I don't think you can really predict how this is going to how it's going to come out. But the impact of the rule is enormous. And I really think the fact that it was kind of rammed through, notwithstanding all these court rulings that seem to be striking down what EPA was doing, is, I think, going to resonate, and that's going to be troubling to some justices. So we'll see. Thank you, Toba.
Thank you. Thank you. I'll now pass on to Jewel and Jordan for some more questions.
Okay, thanks.
All these Supreme Court discussions end up being pretty complicated, and they all have such big implications, which are far-reaching and hard to predict. But first question is, did you say that there was an appeal, that this was appealed, or was the appeal to that the states didn't have to start enacting these regulations before the appeal to the Supreme Court was heard? Could you go over that quickly?
Yes, in the U.S. Court of Appeals for D.C. Circuit, the D.C. Circuit here in Washington, some of the 11 states, 3 of them, and the industries that are most affected by this did go to that court. They are actually in that court, challenging the legality of EPA's federal plan. And that case is still continuing. They haven't even reached the merits of it. So they haven't had a chance yet to argue that EPA's plan is, what they're saying is, it's arbitrary and capricious. EPA didn't consider all the factors it needed to. It made some mistakes about certain things. It didn't give the states an adequate opportunity to comment on what it was doing. Complicated administrative law arguments. That hasn't been heard by the court in DC yet. But at the outset of the case, they also filed a motion for a stay. They sought an order from the court to block EPA's rule from going into effect pending the outcome of the court's decision in the case. And the panel of 3 judges voted 2-1 to deny that request for an order blocking EPA's rule. And that's why they've filed this emergency application in the Supreme Court, now asking the Supreme Court to block EPA's rule while the DC Circuit hears the challenge to the federal.
So the same party, should call it, has brought this case to the circuit court in DC and Supreme Court. Okay.
Yes, that's right.
I have a question about the timeline. It seems like the EPA is just allowed to really control the whole landscape of timing. And from what I understand, they really drug their feet in the beginning when the states gave them their propositions, but now they are
Yes.
able to speed it up and almost force these decisions. So could you just explain a little bit why it why it's able to be like that? Why can it shake out that the EPA can really just control the timing of everything and not give the states time,
Yeah.
same time they
Yeah,
had?
no, you're right. The way Congress structured this is first EPA sets or changes the standard for pollutant, and that's what they did in 2015. And then the state, if they change the standard, make it tougher, then the states have 3 years to come up with a new state plan to say how they're going to come into compliance with that new standard. And the states are supposed to hear comments from the public, take into consideration all the factors, and work out a workable scheme for how they're going to do it. It might require restrictions on industry, permit requirements. These are difficult choices, a lot of trade-offs. So Congress wanted the states to do that at the local level. They have 3 years. Then when they file their plan with the federal government, with the EPA is supposed to decide whether to approve it or disapprove it within 18 months. Unfortunately, there doesn't seem to be any strong, clear way of enforcing that 18 months. And what you had here was the plans were filed in 2018 during the Trump administration. And there was back and forth between the states and the EPA on the details of the plan. The EPA didn't indicate to the states that they had any problems with the plans. And the 18 months passed. Now you have a whole new administration, the Biden administration. And it seems pretty clear that the EPA and the Biden administration decided they had a new grand plan for how to create it's a national market they wanted to create of these 23 states. It's complicated. They've got trading of allowances, pollution allowances and stuff among the states and the different power plants within the states. And they clearly had a big idea, big plan. And so what they decided to do was, hey, let's just deny all these plans. Let's disapprove them. And then let's impose this grand plan of our own. And that is what they did. They did it rather surprisingly. They just sort of said, all on one day, 21 states, your plans are disapproved. And as I said before, those decisions to disapprove those plans are also separately being challenged in courts of appeals around the country. And 7 different courts of appeals have ruled, have blocked EPA's disapproval of the plan. So it's really complicated. There's a lot of different separate actions going on here that are interrelated.
It's when we hear these stories and these things put in these parameters, these regulations, the ways that the the ways that the organizations that the administrative state kind of the executive power basically empowers, that the Congress has given power as well, with the EPA particularly here. There's always people behind these organizations, and what seems is at its very, very worst. Hopefully it's not the case, but at its worst, the EPA people at the EPA decided to wait. If they were all changed out, I really don't think so, but maybe, I don't know who newly Biden appointed. That the new administration, President Biden administration, appointed.
Only the very top thin layer is political appointees that get changed out between administrations.
So possibly when they enacted these new plans, which could have serious detrimental effects on everyday people, possibly the states feel like this could hurt their state economy, feel like it could hurt people in their state, or they wouldn't be fighting it, or they feel like they're just unable to comply for whatever reasons, or they feel like there's a moral reason even where they shouldn't have to comply. I don't know each of their cases or why they're fighting this, but there's people at federal organizations which carry these things out And what seems difficult in our political process right now is that when a state or a citizen goes up against a federal organization, it's never the person in that role. It's
Right.
always you're fighting the EPA. Even
Right.
if the person may have done something that we could think is really terribly immoral or terribly on the very cusp of some conniving or negligence.
Mhm.
It seems really hard to correct, or really hard in our political system right now for us to come to some form of justice in it, where if right now the EPA says I can't, build a shed for some reason in my backyard, I now have to go fight the EPA. I can't ever get to that one individual who made that choice, and that person's probably never going to be held responsible. This came up in an FBI episode once that we
Yeah.
did. It's really so. It's a little disheartening when you hear about what's happened to people, and you realize that, but we we're probably never going to hold the entire EPA accountable. We also don't hold the people accountable. So you're well, I have a lot. I don't have a solution, so I'm asking what in our
Well,
political framework, what do we do with this?
well, that's the concept. That's the concern behind federalism, because federalism says that for purposes of effective accountability, what we want ideally is for decisions to be made at the local level, where you know who's making the decision, they know who you are, you have a better opportunity to have your voice heard, you have more process that's really effective, due process, and it's more transparent and understandable. And if the citizens are not happy with the choices that are made, they can replace the officials who make those choices more easily at the local level. Now, you can't solve, as Tova was focusing on, you can't solve every problem that way, but federalism says to the extent workable, practicable, we err on the side of doing it at the local level. And it's exactly for those accountability principles that you're talking about. The EPA is, it's unknowable who it is unaccountable to the average citizen, and it's making momentous legislative-like decisions that in the old days were, these are big political, philosophical issues that are raised by the power of the administrative state, which is really what we're talking about. Thank you.
Thank you.
Well, and thank y'all for great questions. We're going to go to some audience questions now. But before we do, we want to recognize our teachers and students who are watching with us today. We want to give a shout out to Cherie Stiegel with homeschool students and Hope Bucklow with homeschool students. We also want to thank our listeners on Las Vegas's KKVV 1060 on the radio dial. KKVV airs these programs Monday evenings at 6 p.m. Pacific. So thank you to everyone in Las Vegas listening. So actually, we have a student who's asking a question here. Steve, Hope Mucklow's homeschool students asking, has the EPA ever mass disproved state plans prior to the ozone issue of 2015? And then also, how much does any challenge cost when a state contests a federal agency?
On the first question, I believe this is the largest example of disapprovals all in one fell swoop. Usually EPA works on a state-by-state basis with state plans and finds issues with them, and they're on different schedules with different states, and they work with the states. Historically, they try to make the state plan work. And then if there's an issue, they'll disapprove it. This was clearly a decision made, I really think, motivated by a desire to move to this broad federal scheme that they wanted to put into place. Now, there have been prior instances where they've had a multi-state framework like this, and the Supreme Court in 2014 said they could do that. So they're working on the template that was previously approved by the court. But I think this is at least the biggest example of a mass disapproval. And when it comes to the costs that the states incur in challenging, the states have attorney general's offices and solicitor general's offices for bringing cases like this. They do get a lot of support from private industry that's also challenging it. Private industry expends a lot on their lawyers and their challenge to this, but the costs of the litigation really are pretty significant. Here, I think the costs of compliance are much, much greater. And that's something the states and the industry spend a lot of time trying to develop. And partly what's at stake for the states is that the impact on some of the upwind states will be so significant that they are concerned they won't be able to compete with other states as to the same extent that they currently do in terms of attracting business, employment, economic development, etc. So there's a lot at stake for the states, and I'm sure they find it worthwhile to incur the litigation costs of challenging something like this.
Well, thank you. And Robert Zimmerman has an observation. He says, I would assume states like Texas would immediately appeal an unfavorable opinion. Crushing economies of states with so short timelines of transitions seems to be a desire to end capitalism and make our country one of the cleanest in the world, but would be totally uncompetitive with some of the most polluted countries in the world, such as China or India. It will also end most small businesses who in no way can comply.
Yeah, and also at stake here, sometimes forgotten, is a lot of these rural electric cooperatives that are the power source in a lot of the states that are involved here that are, more rural. And the impact on them is going to be pretty tremendous. Texas did challenge the disapproval of the Texas plan, and Texas got an order from the U.S. Court of Appeals for the Fifth Circuit, which is the regional circuit court of appeals in the Texas area. It got a favorable order blocking the effectiveness of EPA's disapproval of the Texas plan. So Texas is one of the 12 states that EPA has cut out of the federal plan, at least for now, because Texas won an order in the Court of Appeals. And so Texas is not in this case. Texas is not one of the 11 states challenging it. The lead states are Ohio, Indiana, and West Virginia challenging the federal plan, because currently Texas is outside the federal plan. If Texas ultimately loses its challenge to the disapproval of its plan, then it'll be back in this federal plan, and it will. You can bet join this challenge as well.
Well, thank you.
Thank you.
One of our board members, Jay McConville, is watching today, and Jay asks, what is the extent of the EPA's enforcement power? This seems very complicated and expensive. What if a state just refused to implement the EPA's mandate? As I understand it, the action and the cost is all borne by the states. Is that correct?
Well, under the federal plan, EPA basically takes over the role of the state. And what EPA will then start doing is EPA will directly impose the requirements on the paper mills and steel mills and natural gas pipeline companies and electric power plant operators. And so it will be EPA who comes knocking with the federal forces and the coercive power and enforcement power of the federal government. So you just, switch one sovereign for another effectively when EPA is implementing its own federal plan. And so it's really not enforcing it against the state. It's enforcing it against all the private parties that have to comply with the pollution control obligations that EPA is imposing on them.
Okay. And then Vincent Romano asks, have any states that support the EPA rule challenged Ohio, Indiana, and Virginia?
Yes, there's a whole group of states that are in this case on the side of the EPA. They call themselves the downwind states, and they represent the interests of the citizens of those states who have high pollution levels, and they've incurred a lot of costs on their own industry to try to comply, and yet a lot of the pollution is coming from out of state. Now, the curious thing, which I mentioned before in response, I think, to a question that Jewel or Jorn raised, is that there's overlap. A lot of the states that are quote unquote downwind states are also upwind states for other purposes that are, in the group of 11 that are subject to this rule, but they actually support the policies. And so those are more blue states. So New York, Maryland, Pennsylvania are in on the side, also Michigan, Illinois. All of those are both downwind and upwind states. But here they're before the court, and they actually had a representative from the Attorney General's office in New York, a deputy attorney general who works for Letitia James in New York, named Judith Vale, who argued in the Supreme Court on the side of EPA. So they're very active, yes.
Okay. And then Richard MacArthur asks, what's the constitutional authority for Congress to enact environmental laws? Air pollution doesn't seem like interstate commerce.
Well, that's absolutely right. But the Supreme Court in the 20th century expanded greatly the concept of interstate commerce subject to regulation by Congress. And it's basically anything that has a direct or indirect substantial connection to commerce. And so if you think about it, if Congress can regulate goods and services that move across state lines, then what Congress is effectively doing is saying when those goods and services are produced, they have to be produced in ways that meet these environmental requirements. And so because there's that indirect connection to commerce, this all flows under the interstate commerce clause of the Constitution.
Great. And then I think Mark Roberts asked a question that's really great to close on today. Mark asks, how can ordinary citizens be informed properly of the cost their taxes will have to pay for these regulations imposed on us without our having any control, especially when Congress is happy to pass the buck?
Well, that's a great question. Certain members of Congress, Mike Lee, others like to publicize those numbers. There are certain think tanks that work on generating them. The Mercatus Center at George Mason University does that to some extent. My institution, the Heritage Foundation, does, the American Enterprise Institute. There are a number of groups where you can go online and try to find those numbers about the actual economic costs of regulation. It's enormous. Trillions of dollars.
Thank you. And thank you for being our guest today. And thank you for all the great work the Heritage Foundation does. The Heritage Foundation does some incredible research, and what you just mentioned, the cost of regulations, is just the tip of the iceberg on the great information that you can find on the Heritage Foundation website. So I just want to give Janine or Jewel or Jorn or Tova any quick closing comments that y'all might have.
Just thank you for your time and have a great day.
Tova, thank you. Thanks, everyone.
Thank you all. And we hope everyone, our audience, will join us next week, Tuesday at 2:00. We're going to be talking about the Securities and Exchange Commission and a big Supreme Court case coming up with that. So thank y'all.